us for today's presentation on discrimination, harassment, and EEO laws. And even though we do this training annually, there's always something new to learn. It's always different year to year. And this year, the training is being presented by Rachel Kessler, who's an associate in the Labor and Employment Department at Proskauer. Rachel represents clients in a wide range of employment and labor management relations matters and is involved in representation of clients in a diverse range of industries. As part of her employment practice, Rachel focuses on employment-related litigations in state and federal courts before state and federal administrative agencies and in arbitrations. She regularly assists in defending employers from claims involving discrimination, retaliation, harassment, breach of contract, whistleblowing, wrongful termination, and other employment-related torts. And she also counsels on a variety of labor and employment matters, including workplace investigations, as she conducts trainings on topics such as discrimination, harassment in the workplace, and NLRB employee relations. Rachel also maintains a strong pro bono practice and has twice been awarded Proskauer's Golden Gavel Award for Excellence in pro bono work. And she's represented incarcerated clients in parole proceedings and is an active member of the firm's Reproductive Rights Task Force. So Rachel, thank you so much for being here and presenting to us today.
Thank you so much, Lauren. I'm happy to be here. And thank you for all of you in person and on Zoom. As Lauren mentioned, I'm an attorney at the law firm Proskauer Rose, and I represent clients all the time who don't follow the advice that we give them in these trainings. So the goal of today is to go through what I know many of you have heard many times, but to just refresh your memory and your recollection, and to hopefully learn something new, and to just guide us through how we should be thinking about cultivating a respectable work environment and preventing discrimination and harassment in a diverse workplace. Oh, I think I have to. Okay. So what are we going to cover today? We'll define and explain discrimination and harassment. They are similar, but not the same exact thing. And there's different facets of each that we should focus on. We'll talk about the different federal, state, and local laws and the policies that govern discrimination and harassment in the workplace. There are some differences that are important to highlight based on many of us being in New York and then New York City. We'll identify discriminatory and harassing conduct and discuss about how to be an active bystander. And we'll do that in me explaining and also some hypos and some video clips. We'll talk about what is bullying, why, even though it might not raise to the level of unlawful conduct, it's still a matter of concern in the workplace. And when and how to escalate concerns that are raised to you or that you overhear, particularly in that you are all managers in some way, and there's some extra areas of law that we want to cover and ensure that you're all aware of. I think whoever joined is not on Zoom, mute. And then we'll talk about retaliation and, again, some of the special responsibilities of managers to ensure that the city bar's policies are followed. So as you all likely know, culture starts at the top, right? So that's why leadership and accountability are really critical in cultivating a respectful work environment. And the city bar holds all levels of management and supervisors accountable for maintaining a harassment-free workplace. We'll just start by discussing some important terms that are going to guide our discussions today. The first one is discrimination, and that is differential treatment based on a protected characteristic that includes race, gender, age, disability, sexual orientation, nationality, and a variety of other characteristics. And there's also discriminatory harassment, and that's defined as unwelcome conduct related to a relevant protected characteristic, like the ones I just mentioned, which has the purpose or effect of either creating a hostile work environment, or otherwise adversely interfering with or affecting an individual's work performance. And we'll get into this a little bit more, but one of the biggest differences between discrimination and discriminatory harassment is that for discrimination, you need to have the intent to act that way. For harassment, intent doesn't matter. Whatever you say, the effect of it is what matters, and the effect of it and how the person perceives what was said. So that is really important to think about what you're saying and how it might come across, regardless of what your intent is in saying it. So some of the federal anti-discrimination laws that will really be diving into almost all of these throughout the training today. Title VII prohibits discrimination on the basis of race, color, sex, national origin, religion. Sex has over the years been expanded to now include pregnancy, sexual orientation, and as well as gender identity. And if you think about it, this applies to everyone, right? Everyone has a race, everyone has a color, everyone has a sex, a national origin, maybe a religion, but the fact that you don't have a religion would also be applicable here. So it's important to just think about this holistically. We also have Immigration Reform and Control Act, which protects people on the basis of their citizenship. The ADA, which protects people on the basis of a physical or mental disability. Age discrimination, the federal law protects individuals who are age 40 and over, but as we'll talk about later, New York City actually protects individuals 18 or older. And then the Uniformed Services Employment Reemployment Rights Act protects individuals who have military or veteran status, and the Genetic Information Non-Discrimination Act, GINA, regarding genetic information. And under every single law that we've spoken about on this slide, and also just in general today, retaliation is prohibited under all of these. And we're going to get into like specifics on all of this, and that's just a general overview. And then some state and local anti-discrimination laws. Most states have some sort of additional law in addition to the federal baseline, really, and especially in New York, there's the New York State and New York City human rights laws, which provide even greater protections to individuals, including gender expression, marriage or partnership status, family or caregiver status, victim of domestic violence or stalking, traits historically associated with race, this including but not limited to hair texture and protective hairstyles, reproductive health decision-making, and height or weight. The height or weight is actually more recent, as well as the traits historically associated with race. Regarding the height or weight, it's a violation of those protections for an individual to engage in conduct based on someone's height or weight, whether it's one way or another, refusing to hire someone, refusing to promote them, put them into a specific role, anything like that. So that's some of the examples of how New York State and New York City laws are a bit more expansive than the federal. So in talking about harassment, what kind of conduct can rise to the level of harassment? In New York, as well as some other states, but obviously this presentation is focusing on New York, harassment does not need to be severe or pervasive, which is something you've likely heard in the past. Over the past few years, it's changed, and now it's harassing conduct in New York if it rises above a petty slight or trivial inconvenience. So what does that mean? It's litigated every day and people fight over what it means. But generally, it's any behavior in which an employee or other covered individual is treated worse because of one of those protected characteristics that we talked about a few slides ago. And that may be considered harassing behavior. Like I mentioned, the intent does not affect the outcome here. It's what the person who's alleging the harassing conduct perceived it to be. So you could have the best of intentions, but that won't negate what was said or done. The city bar has a comprehensive EEO policy, which prohibits discrimination on the basis of actual or perceived, so what you might think someone is, race, color, creed, religion, national origin. This lists many protected characteristics. This is on their intranet, so I would refer you there. You don't have to memorize it, but it's good to be aware that this exists, and that this is the policy that you should ensure you are in compliance with. And of course, the city bar also has an anti-harassment policy, which kind of just codifies in your policy what I already spoke about in terms of it being prohibited to harass people on the basis of all those protected characteristics, including harassment generally on any of those and/or sexual harassment, which we will talk about later. So when and where can harassing conduct happen? The short answer is anywhere and everywhere, right? It can be in hiring. Just because someone is not yet an employee of the city bar does not mean that they are not afforded the same protections that we've discussed. It can be during training. It could be in the workplace, like the people sitting here today. It could be on Zoom and while you're working from your home. It could be in a meeting that has a professional purpose, or it could be at the water cooler afterwards when you're talking about what happened over the weekend. It could be at company-sponsored events that are both on and off-site, and it could be at anytime you're traveling on behalf of the city bar. And it could be over GChat, it could be over Microsoft Teams, anywhere and anytime that workplace colleagues interact with each other, there can be harassing, discriminatory, or other inappropriate conduct. Title VII, we talked about this a few slides ago, protects the discrimination on the basis of race, sex, and a bunch of other protected characteristics. Some comments to just think about to avoid regarding race, ethnicity, national origin, and religion, using slang words. Workplace isn't the place to do that. Anytime you're interacting with colleagues, even if you're a member of that group, just because you are a woman doesn't mean that you can use slang or derogatory terms to describe other women. Of course, lumping whole groups together, whether it's saying something like the blacks, all white people do this, Asians do this, Jews act this way, that's inappropriate and really in any context shouldn't be said. And then making stereotypical assumptions and or acting on them. I think that we all are well aware of how problematic making assumptions can be about any one person or any group of people. And I would encourage you all to refrain from doing that. So we have, this is our first of several typos that I want to discuss with you. All of these are taken from variations of real life cases and events that we have seen happen in the workplace. So I just wanted you to think about critically as you're thinking about these. They're not detached, they're not cosmic. All of these are real life things that can happen. So Jonathan's supervisor, Lisa, is constantly smiling at him, touching his arm when they talk, and scheduling meetings with him just to catch up. Everyone in the office jokes about Jonathan being Lisa's pet, but it is true that she gives him the best assignments, and Jonathan does not discourage Lisa's behavior and sometimes even jokes about it with his coworkers. One night, the two of them are working late. Lisa calls Jonathan into her office, closes the door, and says, "You know, I see how you look at me. I've been scratching your back all this time. I think it's time that you scratch mine." So a few things here. doesn't matter that Lisa is a female harassing Jonathan. Doesn't matter that Jonathan has flirted with Lisa and hasn't discouraged her behavior. What do you guys think? I see a lot of head shaking, so that's good. It doesn't matter that she's a woman. Women can discriminate against men. Women can discriminate against other women. And it doesn't matter that he's encouraged the behavior, because this last sentence here about, I've been scratching your back all this time, I think that it's time you scratch mine. That's tying it to the workplace, right? She's been giving him the best assignments. Everyone knows that. And now she wants a reciprocal action for that. And that is not only inappropriate, but also rises to the level of unlawful conduct. What you are allowed to do here, we'll kind of talk about this on the next few slides, is you have one bite at the apple. You can ask someone once if they want to go out with you, or anything like that. If the person says no, then you're done. You don't get to ask them again. It doesn't matter if you think that another opportunity has presented itself, maybe the person changed their mind, you're done. You got to wait till the person comes to you, if at all. The correct thing to do in this situation, if Lisa genuinely did have feelings for Jonathan and thought maybe that he would want to go out with her, is for her to ask him. And if he says no, that's that one bite at the apple, then she's done. But none of this can be tied to work. So her asking him would be separating it out from work. The fact that she says, I've been scratching your back all this time, you scratch mine. Maybe that's not exactly how people would say it today in the workplace, but the implication is there, right? And we all know when the implication is there, and that's something we want to avoid. And also just the last thing on this is power dynamics. This is really designed to highlight that it's inappropriate for her to initiate this because she's his supervisor. If this was a peer to peer, we'd be talking a little bit differently, but the fact that she is the supervisor, she holds the power in the relationship, makes this potentially unlawful. And now we have a little video. I don't know if I can play it or they need to. Yeah.
Issues and asked me to look.
So potentially a little cheesy, but you get what this is getting at here. So, I mean, the big thing here is racial microaggressions, right? You can't single someone out and ask them to speak on behalf of their race. That's totally inappropriate. And going back to some of the things we were talking about in the beginning, it's also assuming that one person can speak for an entire group of people and that entire group of people has the same beliefs and outlook, which of course is not true. And he really shouldn't be asking his opinion at all about this. It's not his job. This would be different if they were in the DEI office together and working in that position, but that's not his job. If the boss wanted feedback on this, the proper thing to do would be to go to a DEI office or a DEI officer to ask for his opinion and feedback and help on the presentation itself, but not on the beliefs of a group of people. Okay, so some gender identity protections, which we spoke briefly about earlier. Under federal law, Title VII's prohibition on discrimination because of sex includes discrimination based on sexual orientation and gender identity. This happened in 2020 after the Supreme Court held that because of sex also includes sexual orientation and gender identity. This has had really far-reaching implications on states and cities and just like nationwide. And for New York, for example, discrimination or harassment on the basis of gender identity, gender expression, or sexual orientation all constitutes sex discrimination and or sexual harassment. So this has spurred just the passing of new laws in various states, cities, and really forcing employers to think about this in the way that they cultivate their work environments. So there are, of course, many gender identities, but the three most common that I want to highlight for you all are cisgender, which is when a person identifies with the sex that they were assigned at birth. Transgender, which is when a person whose gender identity is different than the sex they were assigned at birth. And then non-binary, which is when a person does not identify exclusively either as a man or a woman. So the same as when we were talking about Title VII in terms of sex or race, religion, any of those aspects, same thing here for gender identity. No employee should be terminated on account of their gender identity or expression, asked to use a segregated facility, whether it be a bathroom, an office, a workspace, anything like that, or asked to provide medical or legal documentation because of their gender identity in order to have access to those gender affirming facilities. And we want to respect and use individuals' preferred names, pronouns, or titles, regardless of whether it is your preference. When someone tells you what their preferred pronouns are, it's not our job to investigate it further. It's your job to respect that and use those pronouns and names. Another video. So a few things here, getting back into the discussing harassment. You can harass someone remotely over text, over email, over any chats like I was talking about earlier. Obviously, that joke would be inappropriate in person, right? And so it's inappropriate in writing too. The fact that they are friends really doesn't matter. It still had the effect of making her feel uncomfortable and it crosses the line. Just use your common sense hat. If that would be something that you would maybe feel is a weird thing to say or you think twice about, probably just don't say it. And friends don't send friends nudes, right? Like that's not a thing to say. So along those lines, sex stereotyping. And this is when you're harassing a person because they do not conform to gender stereotypes. And that can constitute sexual harassment or sex discrimination. So when we're talking about sex stereotyping, some of the quintessential problematic conducts can include commenting that a female employee would look prettier or more professional if she wore red lipstick, or you would look great if you pulled your hair back, or you should really wear a dress and heels to this client presentation. anything like that. Assuming that someone enjoys or understands certain things based solely upon their gender identity. So you're a guy, you must spend all day watching football on Sunday. Or reacting negatively to a person performing a job that is or usually was obviously performed mostly by persons of a different sex. So that could be, that's a woman's job, referring to administrative positions, or like men should be partners at law firms, something like that. And then drilling down into this a little more, sexual harassment is another subset of this. And the EEOC guidelines define sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And there's two types of sexual harassment that are important and that we should talk about. The first one is quid pro quo, and this relates directly to all of you and is kind of that example that we looked at in the beginning, because that is conduct by a supervisor. And that is where there's an explicit or implicit promise in exchange for sexual conduct. And that's exactly what we were looking at, right? Like, I'll give you the best assignments if you sleep with me, if you sleep with the boss, whatever. Hostile work environment. This can be between anyone, coworkers, two supervisors, coworker and a supervisor. That is when there is unwelcome conduct committed by anyone that interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. And anyone really means anyone. It can be a supervisor, a coworker, an independent contractor, a vendor, a client, a customer, a partner, etc. Some examples of conduct that might create a hostile work environment of a sexual nature. Unwelcome touching. Obviously, you can think about egregious examples of forced kissing or something like that, but it also can be as simple as brushing up against someone, putting your hand on the small of their back. Little things like that can rise to the level of a sexual hostile work environment. Like we just saw in that previous video clip, telling, texting, or emailing sexually explicit or demeaning jokes, suggestive comments about appearance or dress. There's a difference between saying, oh, I really like your suit, where did you get that? And wow, that dress makes you look really good. Just use your common sense, think about what you're saying. Discussion about sexual thoughts, fantasies, or activities. You would be surprised about how many people think the workplace is the appropriate place to talk about sex dreams or stuff like that. It's not, newsflash. They're leering, catcall at someone, sexual gestures, all of that's inappropriate. Love letters or phone calls, repeated requests for a date with someone who's not interested. Like I talked about before, you got one bite at the apple. And it doesn't matter if you think it's a joke. If someone rejects you and then you say, oh, do you want to go on a date? Oh, just kidding. You already said no. That's inappropriate. You already had your bite at the apple. You really should just drop it and not talk about that again. And, obviously you can interact with your coworkers, and most interactions are not hostile and not creating work environments that we need to be concerned about. But it's just important to think about the context of what you're saying. And even with the example of, I really like your suit. Don't say it all the time, probably. If you compliment someone every day, even if it's really platonic like that, it can become harassing. It can become uncomfortable. So just think about what you're saying. And also for everyone here, your power dynamic. So when you think about this in context, a single allegation against an organization can have really widespread repercussions for that organization. So a working paper reported by Harvard Business Review researchers found that even a single allegation about gender discrimination and sexual harassment can damage the way people view an entire organization. It doesn't matter if it's a different department or just a single person. They can have really large ramifications for the city bar. So that's why it's really important to take all of this in context, think about what you're doing, saying, use your common sense hat. There's really no need to become famous by associating yourself with harassment or something like that. We want to avoid that. So some harassment complaints that commonly contain statements that reflect a few statements now that have barely been coming to the forefront of complaints that we're seeing. So joking about being too PC or not being able to say anything, joking about people who have alleged sexual harassment. I know this is not a huge workforce, and while confidentiality is attempted to be maintained in every way, sometimes things get out, and when you know that someone else has made a complaint, joking about that is completely inappropriate and can rise to the level of unlawful conduct. Complimenting a colleague and then saying, oh, am I even allowed to say that anymore? And then stating that you can no longer speak freely in mixed company or the presence of a person belonging to a particular protected class. And then one other thing that's not on here is that I think we've seen it in the news. It's called the Pence effect, because Vice President Pence had said that he didn't want to be alone in a room with women after all these allegations, the Me Too movement. And that's going too far the other way, right? You don't want to exclude someone, and you don't want to make statements like that I can't be in a room alone with you anymore. That's the same kind of thing as saying, oh, I'm too PC or making jokes about it. So some misconceptions about harassment. Anyone can harass anyone. It doesn't matter if you're a man, you're a woman, what race you are, what religion, what national origin, your gender identity. Anyone can harass anyone. So don't think that this doesn't apply to you because you might not fall into what you're thinking of specific buckets, because it does. And the law recognizes that members of the same sex can sexually harass each other. Like I said, women can harass women, men can harass men. I think we've touched on almost all of these in some of the hypos that we've looked at, but you don't need to be the intended target if you overhear something, or if an employee overhears something that's said that is still makes them feel uncomfortable. They can bring a claim for a hostile work environment. Think about shared spaces. What you're saying at the water cooler, someone who sits nearby can hear that, and that might make them uncomfortable. Like we've said, intent doesn't matter, and joking is not a defense. It doesn't go well. I can tell you from experience. And responding to and reporting allegations and concerns related to workplace harassment, even if the perpetrator is not an employee, is really critical, especially for everyone in this room, because you have special responsibilities to report harassment and/or discriminatory behavior. So switching gears a little bit to the Age Discrimination in Employment Act, the ADEA, this prohibits discrimination on the basis of an individual being 40 or over. Like I had mentioned, New York City actually prohibits discrimination on the basis of an individual being 18 or over. So, we used to think of it just under the ADEA as discrimination against individuals over 40, but now it can be individuals who are over 40 discriminating against individuals who are 20 or 25. So it can go both ways. So that's something important to think about. So to avoid any allegations of discriminatory conduct on the basis of age, it's in everyone's best interest to avoid using some ageist terms like grandma, grandpa, dinosaur, okay boomer, or something like we need to bring in some young blood. Millennials and Gen Z are so lazy or don't want to work or anything like that. That's making comments on the basis of age. This is different than just evaluating someone's experience, right? If you're like interviewing someone or looking at someone's resume, looking at experience is different than an age. They're completely different things, but you want to make sure if experience is something you're looking at, you're tying it to that. You're not tying it to someone's age. Now turning to the ADA, which is the Americans with Disabilities Act. This prohibits discrimination against any qualified person with a disability or a perceived disability who can perform the essential functions of the job with or without a reasonable accommodation. And the first thing I want to say here is don't freelance in this area. Go to HR, go to legal. This is not an easily navigable legal landscape. And we have experts in this who can help you navigate what needs to be done. To avoid any potential discrimination on the basis of race, we want to avoid talking about known or perceived physical or mental conditions unless they're raised to you. Speculating about someone, you see someone acting a certain way, you think they may have a disability or a mental disability. We don't speculate, don't act on that. Using outdated terms like retarded, crippled, spaz, mentally ill, he's so OCD, the way he organizes his desk, she's so bipolar, all of that's inappropriate. And revealing an employee's medical condition to this is a really big no-no. Even if you have the best intentions, even if you're trying to help someone, don't do it. It's not our place to educate other people about others' disabilities. And it's important to note that disabilities can be seen, they can be unseen, they can be physical, they can be mental, they can be a variety of different things. So it's not a one size fits all. We're going to talk about this a little more, but employees with disabilities may choose to disclose a disability and then seek a reasonable accommodation. And that requires that employees and employers, so managers, engage in an interactive process. We'll talk about this a little more, but I just wanted to prime everyone on that. So a good example here. 8 months ago, Darius was in a serious car accident and suffered a serious head injury. Upon Darius's request, his employer allows him to regularly come in earlier in the morning and leave earlier in the afternoon, because since the accident, he sometimes gets easily fatigued and occasionally has severe headaches as the day goes on. City Bar then lands a new high-profile project, which the entire team is really excited about. When Darius mentions to his supervisor, Michael, that he is looking forward to digging in on the new project, Michael responds, "Darius, you absolutely do good work, but this one is likely going to require some late nights and travel. All things considered, I think it probably makes sense for you to sit this out." What do you guys think about this one? I see some, I don't know. So the problem here is really with Darius's response, right? That you absolutely do good work, but you should sit this one out, essentially. He can't just make the assumption that it makes sense for Darius to sit this one out. He can say, it requires late night and travel. Do you think you can do that? You propose the option to the employee, and they can request a reasonable accommodation if they want to work on it. He might have said, you know what, I don't think I can do that. And that's fine. And then you don't engage in anything further. But for him to make the decision without posing the question to Darius is where this becomes problematic. If he does want to do it, then you work with him to see if there's a way that he can participate that accommodates his disability without creating an undue burden for the city bar. he can, oh, I already covered that. Never mind. We can continue. So now we'll talk about specifically reasonable accommodations. So the city bar will provide reasonable accommodations to the known disabilities of qualified individuals to perform essential job functions. Like I said, when discussing disability discrimination, this is a mouthful. There's a lot in here. There's a lot of legal terms of art. Don't freelance, go to the experts on this. But it's important for everyone to be aware of the general requirements and to know to raise these issues to HR. Reasonable accommodation requests can also apply to religious observances, pregnancy and medical conditions, and status as a victim of domestic violence, sex offense, or stalking. And we talked a little bit about the interactive dialogue, and I gave some examples in the last hypo. Employees who are requesting a reasonable accommodation should generally request it from their supervisor, or you can also direct them and should direct them to Beth to seek a reasonable accommodation. There can be a lot of different accommodations depending on what disability or religious observance or any of those other things the individual is requesting an accommodation for. It's a case-by-case basis, and there's really no one-size-fits-all. An accommodation might include job restructuring. It could include changing a work schedule, providing special equipment, maybe a standing desk, maybe a different keyboard, maybe a different type of screen, adjusting someone's workstation or location, reassignment to vacant positions, staggering a schedule, providing someone a private space. There's a ton of things, right? And it's important to just not dismiss anything outright and work with the employee. But it's also important to note that not all requests for a reasonable accommodation are reasonable. There's times when the city bar might say, we can't provide you with that accommodation without it becoming an undue burden on us. And then there's not an obligation to provide that. But the purpose here is really to engage in that interactive dialogue, have the back and forth to figure out what is the best path forward for everyone. So social media and the internet. I think we all know by now that the social media and the internet has really seeped its way into almost every part of our lives at all times. And there's some concerns that come with that for purposes of the work environment. Social media can create potential for miscommunication, misunderstanding, and widespread dissemination. You post something on Instagram, it can go viral to all of your coworkers in less than 10 minutes. It also can create blurry lines for personal and professional relationships. Of course, work friendships are encouraged and everyone should be friendly in their work environment, but there are some discussions that are probably best had with non-work friends. And again, use your common sense hat. Think about what's appropriate to say and discuss with people and not. And it's important for everyone to know that any work devices that you have are not your own. There's no privacy on them. If they are furnished by the city bar, you shouldn't expect to have any privacy for anything you're looking at, anything done on those. Don't assume that your office PC is your personal PC. Another case study. Leah, Bill, and Joseph go to grab dinner after work one day, during which Leah snaps a selfie of the three of them. Later, she posts a photo to her private Instagram account with the caption, "Dinner date with the only sane people in the office." Allie, another coworker, follows Leah on Instagram. Allie mentions to Leah that she has been treated for bipolar disorder since she was a teenager, after which Allie felt like Leah started avoiding her in the office. Allie screenshots the post and sends it to Leah's manager saying, "I told you Leah thinks I'm crazy." Leah's manager replies to Allie saying, "I'm not sure why you sent this to me. She didn't say anything about you and there's no need to stir up drama because of someone's private Instagram account." there's a lot going on here. Let's start with, was Leah's post appropriate? And was Leah's manager's response appropriate? So the answer here is that the post is not particularly appropriate, and neither is the response. My first rule of thumb that I want to say about posting on social media is that if you wouldn't feel comfortable saying it in the office, don't post it. What I say to other people who are already in litigation is, if you wouldn't want it read aloud at a deposition, don't text it or don't email it. So that's just, food for thought on that one. But this is a complaint, right, that needs to be raised to HR. When Leah raises it to her manager, that response is brushing it under the rug, not validating the complaint, and not reporting it up to HR. And that can expose the city bar to liability if this turns into something bigger and it was never reported up. She just can't brush off a complaint like that. Oh, and actually one more thing about this. Even though her post had nothing to do with work, right? Like she wasn't saying it was about a work dinner. It wasn't with a client. It wasn't talking about work. The fact that it was with coworkers means it's an extension of the workplace, and you still have to act appropriately no matter where you are. Like we talked about in the beginning, it doesn't matter if you're remote. It doesn't matter if you're offsite. It doesn't matter if you're on Zoom. It doesn't matter if you're at a restaurant. Whenever you're interacting with colleagues, which can be through Instagram, your actions need to be in compliance with not only the city bar's policies, but also the federal, state, and local laws. So, like I just said, interactions outside the office. The city bar's policies always apply, no matter where you are. I think, as we all know, drinking can lead to reduced inhibitions. It's probably not the right time or place to do excessive drinking with your coworkers, because inappropriate conduct wherever you are can make the city bar and or you liable. And failure to intervene and report can also hurt you and the city bar. So Carla, who began at the organization a month ago, is attending an event where several high-profile grantees are in attendance. Midway through the evening, Carla is talking to her manager, Michael, when Richard, one of the grantees, walks up to them. It is clear that Richard has had several drinks and is slurring his words slightly. Richard turns to Carla and says, "I hope this doesn't offend you, but you are absolutely stunning. I've been staring at you all night." Carla is visibly uncomfortable, but smiles politely and doesn't say anything. Richard then puts his hand on Carla's back and pulls her slightly towards him, saying to Michael, "Isn't she a vision?" So let's focus on Michael, because he is the manager in this situation. What can or should he do? Any thoughts? Everyone looks stumped. So he should intervene, but there's a few different ways that he can go about this. One example might be he can directly address Richard and say that's not appropriate. He can pull Richard aside and start some other conversation with him to distract him from the situation so Carla can walk away. Or he can pull Carla aside and excuse them both. If he does pull Richard aside and starts a different conversation with him, he should probably go back and check on Carla afterwards. Or he could have done that, but he's a grantee, so it's complicated. That's why these are all like real life situations, right? It's hard balancing all these competing interests in the workplace, and that's why we like putting hard typos on here. So this brings us to bystander intervention. And it's really important, especially for managers, to understand how to be an active bystander. The first thing is obviously to notice there's a problem. And that's really what the purpose of this training is, to make sure you are all aware of everything that can be problematic. The second is to decide to intervene. And the third is to follow up. This is not a replacement for complaining or making sure a complaint makes its way up to HR. It's really in addition to that. And of course, if you or another individual don't feel safe engaging in bystander intervention, you should never do that. And especially for managers here, you should be conscious again of the power dynamics at play. If you're in a position of power, which you all are in some capacity, your intervention may have a more profound impact on the alleged harasser or potential harasser than someone else's impact. Oh. You can also put your questions in the chat. I can see it. So if you have a question, feel free to do that. Yeah, either is fine. Well, I'll give you, while you're figuring that out, just some like interesting statistics about this. So 70% of women have observed harassment at work, and only 1 of 4 women report being sexually harassed at work. So if you think about like the differences in those numbers there, and then 41% of men have witnessed sexual harassment at work. So if you think about like the amount of time that someone has witnessed it, but don't intervene, think about what your impact can have if you do intervene. Sometimes people think it's not my problem, or if I'm not really sure if I should do anything, if I'm not the target of the harassment, but you can, and these are the ways that you can do so. We can always go back to this for whatever question someone might have. So some ways to be an active bystander. You can interrupt the harassment by engaging with the individual being harassed or otherwise distracting. So that's example. Oh, I see the question now. What if Carla and the grantee enjoy their interaction? Should the manager still intervene? That's a good question. So with harassment, like we said, it's unwelcome conduct. I think that the individuals who are witnessing it as bystanders, it's important to like, again, use your common sense, use social cues, see what the person is acting like. I think there's no harm in still intervening because it still is inappropriate. And if Carla is enjoying the interaction, she can always go back and re-engage in it, if that makes sense. So other ways to be an active bystander: you can confront the harasser, you can ask a third party to help. So maybe in this situation, because you're all managers, maybe it's 2 employees who are observing what's happening, and an employee comes to you and says, I see Richard is like acting inappropriately with Carla. Do you think you can go over there and say something or pull her aside? You can document it for a potential future investigation. And you can check in with the person. Like we gave that example with Carla. If you decide to go the route of talking with Richard and letting her go away, you should probably check up with her afterwards. But you must, not optional, report the incident in accordance with the city bar's reporting policies. So bullying and abusive behavior. Bullying and abusive behavior is not technically unlawful for purposes of what we're discussing today, but it's still important to think about because it can lead to unlawful conduct, and also just has really bad implications for the work environment. And this isn't only about avoiding engaging in unlawful conduct, but also just fostering a really inclusive and cultivating a respectful work environment. So not only is it against the city bar's company policy and won't be tolerated, but it can also lower morale, camaraderie, self-esteem, and reduces productivity, which is usually what a lot of managers care about the most. And like I said, it's often the root cause of complaints and litigation, even if it's not a cognizable legal injury to the person, they might think that it is. And so it's better off not having to go into that realm at all. Some examples can be humiliating people at work, yelling at them, using disrespectful language, some of which we covered earlier, spreading rumors, gossiping, isolating people. You can think about this in a practical sense. An example of that might be forwarding someone's email to someone else and making fun of it. It could be joking about how someone like made a mistake on a project and like going over it too much. It can be making inappropriate jokes about someone's work product to their face or behind their back. But important to note is that difficult conversations are not bullying. Just because we obviously want to protect against any bullying happening in the work environment, it doesn't mean that you can't have the difficult conversations that managers sometimes do need to have with their employees. Legitimate criticism, poor performance, or other negative feedback is not bullying. But what can rise to the level of bullying is when it is disrespectfully conveyed. There's a way to say things right. Really excessive, criticizing someone too much. When I say too much, I don't mean because if you need to criticize them because they're not doing a good job consistently, that's different than picking up little things that you're not picking up for someone else, or going back to the same one issue over and over when it was addressed 6 months ago and the same issue hasn't arisen again. So just some tips for asking yourself and what to avoid. Think about what helps the city bar, right? Like your interests are usually aligned. Could a person reasonably find your conduct hostile or offensive? I like to ask myself instead of that one, or in conjunction with that one, would I find it hostile or offensive if someone said this to me? And like I said before, anything you say on instant message, email, conduct, if someone read it out loud in front of a jury or in front of your parents or in front of your children, would you feel comfortable with what you'd said, and would you be able to defend it? Of course, we're going to avoid derogatory remarks, insults, undermining coworkers' work performance, verbal or physical threats, acts that may be humiliating or embarrassing to other, epithets, and nicknames, unless that person specifically asks you to address them that way. And this is the city bar's complaint reporting policy. This is also found on the internet. No need to memorize this now, but I do want to point out the second bullet that begins with managers and supervisors are required to report any complaint that they receive or any prohibited conduct that they observe or become aware of, even if the conduct doesn't involve a direct report, to the Director of Human Resources or the General Counsel. And those are some additional resources for potentially filing a complaint. So now let's talk about what happens after a concern is escalated. There will typically be an investigation that can comprise of interviews, that can comprise of document reviews. And while most interviews are confidential to the extent possible, sometimes there are instances where you need to, or the city bar will need to disclose certain aspects of what was said or complained of or discussed in an interview. And then the city bar will determine appropriate remedial action if it's necessary, and then provide closure communication. Regarding confidentiality, it's the city bar is the only one who's able to quote unquote break that confidentiality. No one else can do that. And it's really important to maintain confidentiality while an investigation is ongoing. So if you're interviewed as part of an investigation, it's really important not to discuss what was discussed during the interview with other people. There's a variety of reasons for that. We want to maintain the integrity of the investigation. It can also change what people think happened or what they think said, or they'll try to conform to what you're saying, especially if you're a manager. What you say has a more profound impact. Some examples of remedial action, they range really. It could be something small as coaching or counseling. It could be something as large as a suspension or a termination. Obviously, this depends on what happened and what the investigation found, and a variety of other factors. Oftentimes, though, the city bar can't share what remedial action was taken to protect the privacy of employees. You may know as a manager what remedial action happened, but it's not within your control to share that with other employees. And I want to highlight some of the costs of unaddressed workplace misconduct and what that can lead to. There's a variety of different costs, and they're large and small, but together they can add up to be quite costly to the city bar, not only in money and time, but also in reputation, as we discussed earlier, and productivity, because it can impact employee morale. So what should you do as supervisors and managers? First example, a subordinate who you do not supervise, who is also your friend, comes into your office, asks to close the door, and you close the door and she sits down. She says, "I'm not reporting anything, but I just want to talk to you as a friend off the record. I need you to keep this confidential." She tells you that her manager makes her feel terrible. He's always shouting orders at her and using foul language. She seems really upset. You're not sure if the comments are harassing or what. What should you say? What should you do? Any thoughts? So you still have the obligation to report it, even though, good job. Even though she asks you to keep this off the record and I need you to keep this confidential, you are a manager or a supervisor at the city bar, and you have an obligation to the city bar to report this. If you don't, you can expose not only yourself and the bar to, but also the bar to liability. And it's also part of this city bar's policy, right? If something is complained to you, you need to report it. Does it matter that you're not sure if the comments are harassing or what? No. You're not the person who's going to be determining whether it's harassment, whether it's discrimination, whether it's sexual harassment, whether it's bullying, whether it's nothing. Someone has lodged a complaint to you. It doesn't matter if it's categorized as a complaint or not. It's clear that this is what it is, right? Even if someone says, "I'm not complaining, but I don't like how so-and-so did this," or "I don't like how so-and-so treats me." Your job as a manager is to report that. This is true. And this is why it's really important for you to report. So this quote says, "The easiest discrimination and or harassment cases to win are the ones where we can show that the plaintiff told a supervisor and they did nothing." Because that is exactly what opens up the city bar to liability. So just some advice and tips on how to properly receive and report complaints. Listening actively and sensitively, it's kind of our first intuition to want to like jump in and provide feedback or ask follow-up questions, but it's really best to just like listen and think about what they're saying and critically think and critically listen. Be familiar with the non-discrimination and anti-harassment provisions of the city bar's policies, which we just went over. So now you can all check that off because you are all familiar. Don't promise absolute confidentiality. This goes back to with what we just discussed. You are not the ones who can promise confidentiality. It's up to the city bar to investigate them. Keep your feelings and opinions to yourself. You want to be sympathetic and sensitive, but if you are like, yeah, this person is really not good in how they manage their employees, that may come back to hurt you. So it's not appropriate to say something like that. Thank them for coming to you and assure them that there will be a response. Don't say what the response is because you don't know what the response is. Ask how they would like to see the matter resolved. Like, what's their end goal? Do they want to switch reporting structures? Do they want to leave the organization? There's a wide variety of what the outcome could be here. And most importantly, promptly escalate. This is just a little bit more information on what I talked about earlier in terms of recognizing what you should escalate. Of course, an actual complaint, that could be in person, this could be written, it could be over Microsoft Chat or whatever you use. It could be informal, like someone coming into your office, like the example we just went through. It could be you witnessing something. It might not even be someone making a complaint to you or an informal complaint. And that witnessing behavior, it could be something like what you perceive as bullying. It could be something like excessive cursing or degrading employees. If there's unusually high gossip, I think you kind of all have awareness of what's going on and the culture and kind of like the vibes of your direct reports. So just keep tabs on that and see what's going on. So retaliation and avoiding retaliation. Retaliation can involve any materially adverse, so that is another legal term of art that you shouldn't try to interpret, that could discourage an individual from coming forward to make or support a claim of discrimination or harassment, or that seeks to punish someone who has come forward. So this just basically means don't punish someone in a small way or large for making a complaint or for someone who's supporting someone else for making a complaint. This can really range. It can be something as clear as terminating someone for making a complaint or for supporting someone who made a complaint, but it can be smaller. That's maybe a little bit harder to discern. It can be freezing someone out of meetings, taking them off of group emails, criticizing them for things that you hadn't previously criticized them about, and just generally making their work environment more difficult to succeed in. And of course, the New York City Bar policy clearly prohibits retaliation in any manner. And something that is important, I think, for you all to know as managers and supervisors is that it used to be not retaliatory to put someone on a performance improvement plan or something similar. But the law has been changing, and now it's looking like some recent decisions have suggested that that conduct can be retaliatory, depending on the temporal proximity to when someone lodged a complaint. So if you have any concerns about that or putting someone on something like a performance improvement plan, you should talk to HR about that. Some critical steps to prevent retaliation. Continuing to treat an employee who complained the same as every other employee. I can't stress this enough. I handle a lot of internal investigations. And the number one thing we tell every single witness, and especially managers, is don't treat the employee any different. Like, for all intents and purposes, you don't know about it. Treat them the same. Like, don't treat them better than you would have before. Don't treat them worse either. Just the same, status quo. Before taking any adverse employment action, of course, consult with HR. You want to make sure that the action is fair, and also fair in appearance, because that's going to impact the work environment that you are creating. And be discreet. Don't share information with people who don't need to know. This is on a need-to-know basis. Don't gossip about this. If you hear any gossip about it, tell HR, figure out a way to prevent just creating a work environment where gossip is prevalent. And also with be discreet, no, everyone doesn't need to know that there's been a complaint. If they do know, don't talk about it with them. You want to maintain the status quo and kind of keep this as a whole separate area that doesn't infiltrate into your workplace. So we've touched on some of the special roles and responsibilities that managers have, but I just want to highlight them for you in one place. So everyone, including all of you, are subject to the city bar's policies. No one is exempt. Inappropriate conduct on the part of managers can cause liability to the city bar. And managers are expected to serve as role models and uphold the policies, including anti-harassment and non-discrimination and the complaint procedures. Like we said at the very beginning, you set the tone. And you want to set the tone for an inclusive and respectful work environment. You must promptly report and take action to address inappropriate conduct. It could be sexual nature, it could be discriminatory based on any of the other protected characteristics that we've discussed. Or conduct that you become aware of. Maybe you didn't witness it, but you've been made aware of it by someone else. And all those, like we just went through, you must report regardless of whether it's a formal complaint, an informal complaint, you observe it, someone tells you about it, or you even suspect that it's occurring. So the reason why, if you don't report, you can make the company liable is because supervisor knowledge equals company knowledge in terms of employment liability. So basically what you know, that it is considered that the city bar knows, and it's just like automatically imputed to the city bar. So if you knew that someone complained and you didn't escalate it and so nothing was done, the major takeaway of that is the city bar did nothing. And of course, the policy mandates that reporting by a supervisor or manager who receives the complaint is done to a supervisor, is done to HR. A supervisor or manager must report regardless of whether you learn of the events via complaint, observation, rumor, everything we just discussed. I'm just hammering it home because it's really probably the biggest takeaway from this presentation. Discriminatory or harassing behavior committed by a supervisor that results in a tangible adverse employment action. So all the things that we discussed that could be retaliatory, creates company liability, and also can create individual liability. And I know that none of you want to see your names on a complaint filed in federal court. So individual liability, your actions or failure to act can create individual liability. I see this like all the time, almost in every case. There is the main manager involved is named, and that can subject you to personal liability, especially if you didn't take any meaningful steps to remedy the conduct. The more that you do in terms of reporting and making sure HR and legal are aware and can investigate and take the steps to remedy, the more protected you are as a company and also as an individual. And just those, oh, I'm really behind on this. Some of those tangible employment actions that I mentioned earlier, like demotion, termination, suspension, anything like that. In some states, supervisors and managers can face personal liability if they are found to have aided and abetted discrimination and harassment. We do see this in New York quite a bit, so it is applicable here. Harassment claims can also come with tag-along claims like assault, battery, negligent infliction of emotional distress, intentional infliction of emotional distress, libel, slander, false imprisonment. That the list goes on, but they're often not just one claim that's set forth, it's a variety of them, and especially specific ones to managers. I've often see assault and battery in those, which may seem crazy, but that's what we see. So anyone, an employee, a coworker, anyone can be held personally liable under state and city law. So that means you are on the other side of the V in a complaint, and you're personally responsible for your own damages, and that means money is coming out of your own bank account. So final word, what is your role? And I think we've made it clear throughout this presentation, but just to recap everything. So understand that inappropriate conduct hurts your brand, your reputation, your productivity, all of those things. Know the city bar's policies and what to do if you receive complaints or observe or learn that conduct that could violate the city bar's policies has occurred. And so what do you do if any of those things happen? You report it. You can be proactive about identifying concerning conduct and escalating those concerns in line with the city bar's policies. Like I just mentioned, this protects both of you. Understand that the words and actions count more than good intentions. Going back to the beginning, we were talking about harassment. Your intent doesn't matter. It's irrelevant. It's only the effect. And because of the current climate, there's kind of higher expectations concerning prompt escalation of concerns, especially those that managers become aware of. So there's really no reason to sit on it. If you learn about something or someone reports something to you, just report it immediately. And everyone at the city bar, every single person is entitled to equal treatment, and make sure that your interactions with your subordinates evidence equal treatment for all, because I mean, the golden rule, right? Treat others how you want to be treated. And that concludes our presentation. Happy to answer any questions. If you want to go back to any of the hypotheticals, I'm here. And if you have concerns you think of later, I know that Beth and Lauren would be happy to forward any other questions to me. And I hope that this was helpful for all of you, and thank you all for attending. Oh, yes. Hi. Mm-hmm.
To our network vendors to interactions or contexts with our non-staff members.
I would say yes, because it can create a hostile work environment for your staff, right? So yes. Oh, yes. Sorry. So the question was if there is conduct between someone who works at the New York City bar and a member, should you report that? Do the same reporting requirements apply? And the answer is yes, they still apply. And then the next question was, what if it's two members? I think the context is important here. If it's two members who are sitting in a meeting and you're all having a meeting and there are colleagues of the New York City bar there, then I would say yes. And they can't think of many that it wouldn't apply, but just a caveat.
It comes to me, it's the thing, but it's not entertaining. I hear what you're saying. I mean, staff. And sorry, look like what.
It's if you think about some of the hypotheticals that we've spoken about with like remote work or off-site, just because it's not, or the social media, just because it's not on site, it still can implicate people who work for the New York City bar and the environment at the New York City bar. So those reporting and those policies still apply, and the reporting. Yeah. Yeah.
You don't know what's going on. You know that there's something.
Yeah. So that's a good question. It happens like often. Sorry, I keep forgetting. The question was, what if in that scenario you say, before you tell me anything, I do have to report this. It can't maintain your confidentiality. And the person says, okay, never mind. Do you still have to report that? And I, again, would say the answer is yes, because then maybe they didn't want to tell you. Now that they know you have to report it, they don't want you to be involved, but you can tell HR, and HR can always just reach out for a check-in. They don't have to say, so-and-so told me that you said something, but then you stopped. You can just schedule a regular check-in, and that person might disclose whatever they were going to say, or they might not, but then you've done something, and the city bar has done something. Yeah.
Thanks. Someone comes to me who I'm friendly with, but I don't supervise them.
Mhm.
And similarly, they say, I'm not going to file a complaint or anything, but, can I just vent? And I say, but if you complain, then I have to report it. But so it's like, it's venting. So where do you draw the line?
Well, what's the venting about? So that's why when we were going through like what is something you have to report, what's the complaint, is the venting like, this project is so hard and I just feel like I don't have enough support and I don't know what to do. That's
I cut them off and I say, like Elizabeth said, if you complain to me, I'm going to have to report it. And they say, okay, never mind.
Yeah, I think the same answer would still apply. I think it's always better to err on the side of caution and just inform HR, because you don't want the buck to stop with you, right? You want HR to be aware. You want it to stop with them, not you.